This is Barry Zalma on insurance. Today I'd like to talk about an interesting defense to the tort of bad faith. That is the statute of limitations. For example, in West Virginia, a 1-year statute of limitation applies to a statutory bad faith claim. Claims involving unfair settlement practices that reside under the Unfair Trade Practices Act are governed by the 1-year statute of limitations set forth in the West Virginia Code. A common law bad faith claim sounds in tort. The statute of limitations that governs a tort action is contained in West Virginia Code Section 55-2-12, which provides, quote, every personal action for which there is no limitation is otherwise prescribed shall be brought within 2 years next after the right to bring the same shall have accrued, if it be for damage to property, B, within 2 years next after the right to bring the same shall have accrued if it be for damages for personal injuries, and C, within 1 year next after the right to bring the same shall have accrued if it be for any other matter of such nature that in case a party die, it could not have been brought at common law or by or against his personal representative. Close quote. Therefore, in West Virginia, the 1-year statute applies to the tort of bad faith. For a common law bad faith claim, a claimant need not wait for resolution of the underlying claim before bringing a bad faith action, but can proceed when the last fact essential to the cause of action arises, whether or not damages are finalized. Unlike a statutory bad faith claim, neither a judgment nor a settlement is required for filing a common law bad faith case. In Alabama, the courts hold that the 1-year statute of limitation governing tort actions applies to a suit by an insured against its insurer alleging negligence or bad faith in settling a third-party claim, because it is a tort claim, not a contract action. There the court noted, in a case called Waters v. American Casualty, that there exists a division among the jurisdictions as to whether the liability of an insurance company to its insured is based upon bad faith or negligence. The West Virginia Supreme Court previously held that a 1-year statute of limitation applies to statutory bad faith cases. Wilt v. State Farm Auto, a 1998 decision of the West Virginia Supreme Court. Claims involving unfair settlement practices that arise under the Unfair Trade Practices Act are governed by the 1-year statute of limitations. Although the circuit court and the parties assumed that a 1-year statute of limitations applies to a common law bad faith claim, the court has never expressly determined what statute of limitations period covers a common law bad faith claim. However, in Sizemore v. State Farm, a 1998 decision, the Supreme Court was asked whether the 1-year statute of limitations was applicable to a common law bad faith claim. In Sizemore and Nolan v. Virginia Insurance Reciprocal Association, a 2009 decision, the court concluded that the 1-year tort statute of limitations applied. Now, with these statutory limitations, one must also wonder whether the tort of bad faith has run its course. It must be recognized that U.S. law was first organizing using English common law. Under English common law and under the basic U.S. contract law, when a contract was breached, only the damages contemplated by the contract could be recovered. Tort damages were limited to tortious conduct, and the two categories of damages were believed to be mutually exclusive. The primary purpose of damages for breach of contract is to protect the promisee's expectation interest in the promisor's performance. Damages should put the plaintiff in as good a position as if the defendant had fully performed as required by the contract. Insurance, like all parts of modern society, is subject to the deprivations of the law of unintended consequences. The law can be defined as the understanding that actions of people, and especially of government or the courts, always have effects that are unanticipated or unintended. Insurance is controlled by the courts through appellate decisions, and by governmental agencies through statute and regulation. Compliance with the appellate decisions, statutes, and regulations, different in the various states, is exceedingly difficult and often very expensive. Insurance contracts can be simple or exceedingly complex, depending on the risks taken by the insurer. Regardless, insurance is only a contract whose terms are agreed to by the parties to the contract. Over the last few centuries, almost every word and phrase used in insurance contracts has been interpreted and applied by one court or another. Ambiguity in contract language became certain. However, the average person saw the insurance contract as incomprehensible and impossible to understand, although in reality is probably the easiest and simplest in contracts ever written. Ostensibly to protect the public, regulators decided to require that insurers write their policies in easy-to-read language. Because they were required to do so by law, insurers changed the words in their contracts into language that people with a fourth-grade education could understand. Precise language interpreted by hundreds of years of court decisions was disposed of and replaced with imprecise, easy-to-read language. After the creation of the tort of bad faith, if an insurer disagreed on the application of the policy to the factual situation, damages were no longer limited to contract damages as in other commercial relationships. If the court found that the insurer was wrong, it could be required to pay the contract amount and damages for emotional distress, pain, suffering, punishment damages, attorney's fees, and any other damages the insured and the court could conceive. Insureds who are wronged by their insurer should only be limited to contract damages as any other party to any other contract is limited. They should be compelled to waive the tort and sue an assumpsit. If the tort of bad faith must exist, must be applied equally, the abuse of the tort of bad faith has become so extreme that, in my opinion, the tort must be eliminated or otherwise made fair. In Essex Insurance Company versus Five Star Dye House, the California Supreme Court concluded that while claims of bad faith breach of an insurance contract are generally assignable, emotional distress and punitive damages associated with such claims are not. As recognized by the court, a claim for bad faith breach of an insurance policy consists of both a contract and a tort claim. an insured may assign the breach of contract aspect of the bad faith claim, but not the tort aspect. Case law has established the proposition that an insured who has suffered damages in excess of an insurance policy as a consequence of the insurer's bad faith failure to settle a claim may sue the insurer for breach of contract. Under settled principles, however, the insurer's duty to settle runs to the insured and not to an injured claimant. Consequently, an insurer owes no common law duty to a victim of a tort by the insurer's insured. Although the insured may assign his cause of action against the insurer for its breach of the duty to settle, he cannot assign the personal tort aspect of that bad faith cause of action because that aspect is not assignable in California. It is not the nature of the relief provided by the tort of bad faith that prohibits a claim for emotional distress or punitive damages from being assigned. It is the nature of the underlying cause of action giving rise to that relief, because emotional distress and punitive damages flow from the personal tort aspect of an insurance bad faith claim. Therefore, they may not be assigned. However, when the facts involve injury to property rather than personal injury, the assignment of punitive damages claim is incidental to the transfer of breach of contract or property losses, and the assignee may pursue whatever punitive damages claim may exist by virtue of the matters alleged in the complaint. Although the bad faith claim was scheduled and initially part of a bankruptcy estate, the Bankruptcy Code will not authorize the bankruptcy trustee to sell or assign assets that are not assignable under applicable state law. A purely personal tort cause of action is not assignable in California, and it must be concluded that damage for emotional distress is also not assignable. Of course, in California and in every other state, when an insured acts in bad faith, the insurer is only allowed to collect contract damages and is not allowed to feel it has been the victim of a tort, nor may it sue its insured for the tort of bad faith. The tort of bad faith, therefore, the unintentional consequence of its creation, is that it only goes in one direction, which on its face should seem to be unfair. This video was adapted from my book, Selma on Insurance Claims, Part 106, Second Edition, which is part of a 10-part treatise, Selma on Insurance Claims, all the parts of which are available as both Kindle books and paperbacks from Amazon.com. If you found this video to be useful or interesting to you or your colleagues, please pass it on. It's free. And please also subscribe to my YouTube channel, my Rumble channel, my blog, and my Substack publications so that you can learn about future blog postings and videos. Thank you for your attention.